In process, it might sound a little like the show Survivor, except that some contestants have been dragged to the island against their will. This week, hundreds of potential jurors gathered daily at the Montreal courthouse for jury selection in the murder trial of Luca Magnotta. One arrived in tears, told the judge she was already having trouble sleeping. Another argued that his English was limited to the words yes, no, and toaster. They and many others were excused. Now the defense and Crown must settle on a jury from the pool that's left. They can try to reject candidates for cause using a formal process. They can also veto as many as 22 people each, without sharing why, and with very little information to go on. So how do they make up their minds? We have invited a couple of Ottawa lawyers to give us some insight into the process. Anne Weinstein and Solomon Friedman are both criminal lawyers, and Anne also spent a couple of years as a Crown prosecutor. They're with me in studio. Hello there.
Good afternoon.
Good afternoon, Alan.
So, Solomon, you don't really get very much information about jury candidates. Remind us what you do get to work with.
Sure. Usually, the morning of your jury selection, or maybe the week before, if you're lucky, you'll get a printout with a list of names. You'll get an occupation, and you'll get their address, so you'll know roughly where they're residing. And with that information, you have to, determine in some way whether you think that person would be a good fit for your jury.
So honestly, what do you start looking for when you're trying to screen out people in a jury?
Well, some lawyers don't try to screen out at all. Some lawyers say, I'll take the first 12 that arrive. Others will use maybe, I say, more nuanced or more spurious process and make some assumptions about the type of work someone does or their educational background and what type of judgment they might possess and what type of life experience they might possess.
Give me an example of the nuance or spuriousness that we're talking about.
Sure. There are defense lawyers who say, for example, that they prefer engineers or scientists, somebody with a hard science background, because that person can parse out information without emotion, and they can look at a case logically and filter out the more sort of inflammatory portions of a trial.
And are you serious that some lawyers are just like, nah, give me the first 12?
Well, you have to remember all this is happening in view of your other jurors. So you have to ask yourself as defense counsel, do you want to be seen by your other potential jurors as selecting, hand-picking, rejecting people for no reason? Maybe you want the whole jury to know, I am so confident in my case, the first 12 will do.
And what would be your approach? What are the red flags that you'd look for when trying to screen out potential jury members?
Well, that depends whether you're asking me as a former Crown or as defense
Yeah, I know.
counsel.
I just realized we could go either way with this. Let's start with Crown.
As a Crown, I think I would take a more relaxed approach because as a Crown, you're a Minister of Justice and you're representing the interests of the community. So any community members who attend and demonstrate that they look like they have an ability to be able to attend to the evidence and pay attention, don't look like they're fidgeting with their cell phones after being told not to text, and are paying attention, and look like they're going to be able to be interested in the proceedings, those are the kind of people who, as a Crown, I'd be happy to accept.
Does that happen where jurors are suddenly fidgeting and playing with their cell phone?
When we're watching them in the panel, when they come in and they're selected to come up in groups, the people who don't want to be there, and I'm sure Solomon would confirm this, you can read their body language loud and clear. People who are fidgeting, who are distracted, who obviously want to be somewhere other than the courtroom, we don't want those people, either as Crown or defense.
And is it... I mean, generally, this sounds like a stupid question, but you don't want somebody there who doesn't want to be there?
Absolutely. Neither as a Crown or as defense counsel. You want someone, no one wants a mistrial. We want someone who's going to be able to listen to all of the evidence and regard the evidence no matter how graphic some of it might be in a murder trial, for example. But as a defense lawyer, I want people who sort of regard the world in shades of gray as opposed to particularly black and white. I'd avoid someone who I thought might have a particular, and of course it depends on your defense. A lot of the people you're going to be looking for, it depends on the nature of the defense that you're going to be running. As defense counsel, I don't want someone that I think, if it's a case where I'm going to be questioning the credibility of a police officer, for example, I may not want someone that I think has got a strong affinity for law and order, but someone who might take a more sympathetic or broader view of my client's lot in life. Those are the kinds of people that I'd be looking for.
Now, how long do you, for people whose only exposure to trials have been watching the quick-paced version of this where it's a montage on television, how long do you have to get to know that potential juror? When you're sitting there screening them, it's fairly obvious if someone was or is a police officer, whether or not they have a certain affinity, but how else would you learn that through the interview process?
Solomon?
Well, I suppose depending on the case, you're going to have you're not going to have very long at all. Really, this is happening the morning of a trial. You have a lot of other important things to do. You've prepared to cross-examine witnesses, and really, there's actually a singular moment where the juror is directed. The words are read out. Juror, look upon the accused. Accused, look upon the juror. And their two eyes are supposed to meet. This is an old common law incantation. And some lawyers try to determine something. Did the juror meet my client's eyes? Did they avert their gaze? And that's really the moment that you have to size up this individual. Like I said, this is definitely more art than science.
So that's a quick judge moment then. Do you look at his eyes? Did he look at his eyes? That's it.
Absolutely. You're completely relying on your gut and reading the tea leaves. And usually I'm furiously leaning over to my junior and saying, what do you think? What do you think? And I'll say the same thing to my client, and ultimately usually let my client have the last word unless it's someone who I really sort of feel averse to. But it's not very scientific.
Is there ever a conversation between junior client and yourself where you don't agree on what you think that juror is about?
I think I would make the final call in that case, especially if it's just my junior who doesn't agree.
but where I'm curious, like whether three people can look on that same person and see something completely different, or how it could affect your case.
Yeah, totally.
Huh.
Yeah,
Solomon?
I can totally see
do you tend to, if you're talking it over with somebody else, see the same thing in a juror?
Well, I guess it really depends on your own life experience, right? We all have different biases, and we all bring those to the jury selection process. So if you have one lawyer who has a positive experience with one type of juror and another lawyer had the opposite experience, you'll end up at loggerheads. But I think many lawyers see this as just one step on the way to the real process, which is the jury trial itself. I think the more you ponder this, the deeper the hole you dig for yourself is, with stereotypes and assumptions, and it can be difficult to escape.
There was a story from the Toronto Star a few years ago where one lawyer said he vetoed men in designer suits. Another one, he said he never wants engineers or accountants because he felt they were more likely to convict.
You see, Alan, I think Solomon likes engineers. He would tell you that he liked engineers.
Oh, really? Yes. All right. Are there other creative shortcuts you use when you're thinking through what type you want?
Well, I did take the opportunity to speak to John Rosen before I came here today, who's done literally probably maybe thousands of jury trials in a lifetime, 45 years of criminal law. And he sort of summed it up by saying he doesn't like people who think in concrete black and white terms. He doesn't like bankers on his jury, for example.
Bankers.
Exactly.
That would be it.
If you're applying to be on Mr. Rosen's trial and you're a banker, you're not going to get there.
Wow.
But
for yourself?
For myself, it would depend on the nature of the case again. I don't think that I would necessarily be opposed to a banker, but perhaps in a fraud case, I might be, it's all depending on the nature of the charge and the nature of the defense you're going to be running. But really, you want someone who's going to be able to think about the evidence. I like jurors who are educated, able to understand the evidence, and are going to think critically. Whether they're university students or people in the workforce, I want someone who's really going to think about, is what the Crown telling me? Am I going to just accept everything that they say, or am I going to have questions? And I want the person who has questions.
And this is obviously so subjective, but is there any evidence, Solomon, about the best way to pick a jury?
Well, that's a great question. The simple answer is no, and it's for a very basic reason. In Canada, jurors are absolutely prohibited from discussing their deliberations or what goes on in the jury room behind the scenes. Unlike in the United States, where jurors generally, depending on the jurisdiction, are free to discuss their deliberations, there's a lot of academic research and science behind it, where you can look at a jury pool, you can determine what their professions, their ages, etc., backgrounds are, and you can look at the verdicts they render and the reasons for rendering them. In Canada, we have a total gap in that research. And, there have been many people who've actually called to change the law and allow jurors at their will, not obviously against their will, to discuss their deliberations if they so wish, so we can learn a little bit and peel back that veil and maybe settle some of these stereotypes and assumptions about jurors.
Although it's interesting, I mean, you have still no time to make these decisions. It sounds like it's the ability you almost need to make snap judgments.
You do. The Americans have a much more expanded system where they have a voir dire system, and there's a lot more questioning that goes into the selection of the jury. In Canada, we have a much more attenuated and rigid approach. I'd like to see the development of a system that's a little more open than what we have here in Canada currently, and I agree with Solomon. I think it would give us some real insight into, for example, we rely on the fact that a judge's charge to a jury or a judge's caution about disregarding evidence, we rely on that as cleansing the jury and being able to allow them to maintain their impartiality. Is that really the case? We don't know. We're presuming that it does, but I think the ability to sort of look at how they reason and how they think would assist us in making sure that we have more fair trials.
Well, thank you both. It's a fascinating glimpse into how decisions get made and the kind of pressure everybody's under at that moment. Both of you, thanks so much for coming in.
My pleasure.
You're very welcome.
Solomon Friedman, partner with Edelson, Clifford, D'Angelo Friedman, and Anne Weinstein is a partner with Weinstein Law.